Good afternoon. I want to start by thanking HFW and the rest of the sponsors for sponsoring this event. I found it great. I was here 2 years ago, and the question was asked about, the same question was asked, would Donald Trump be good for the yacht industry? And I had a slight discussion with my colleague Rob Moss about that. It turns out I was right. I also want to say thank you to David, because we do have a presence on Instagram, and we have got a fairly substantial deal out of Instagram. But I just sent a note to our IT guy that we're going on YouTube. So thank you. The subject of my presentation today is the art of the deal, how a yacht lawyer will help you get it done. As a lawyer, I've come to realize that there are realities about how people in this business think about lawyers. The first reality is that you believe that getting a lawyer involved, most of you, although I did hear some good comments up here earlier, most of you believe that getting a lawyer involved in a deal is a bad idea, because getting a lawyer involved in a deal will complicate things. Why is that? Because lawyers are generally considered to be self-important gas bags. I'm not sure who that is, but he looks pretty important to me. The second reality is that you believe that it's especially bad to get a lawyer involved before a contract is signed. And that's because it's common knowledge that if you do that, the lawyer is going to blow the deal up. The third reality is that most normal human beings, although you all are in the yacht business and maybe you're not normal, most normal human beings hate to read contracts. The best example is the contract that we all see, the little button on our phone or on our iPad or on our computer that says that we agree that we have read and understand the contract before we can proceed to use the device. All of you are a bunch of lazy liars, myself included, but it's for good reason. Who has the time to read all that fine print? No one understands it. And in the end, it's written by a bunch of lawyers who are mostly clowns anyway. Here's an example. This is our Miami office, and the biggest clown of all is the one standing in the back with a stupid smile on his face. He's only smiling because he's already figured out who he's going to stick the lunch bill to, which client is going to pay for lunch. Applying this same principle to the yacht business, if we're honest, how many people have actually read the IYBA Purchase and Sale Agreement or the MEBA Memorandum of Agreement all the way through and then had a conversation with a yacht lawyer about it? The reality is being understood. There are certain situations when things get messy and a lawyer can help. I'll give you 2 examples now and 2 later. Let's start with language in a contract that everybody takes for granted and nobody reads. Like this clause. Oops, that's the wrong clause. We missed the clause. But there is a clause in these contracts that says that the seller will provide proof that it's in good standing if it's a corporate entity. It will provide a consent action that proves that the company has the authority to sell the yacht, and it will provide a power of attorney authorizing the individual in question to sign the documents. So here's the situation. We have a Mexican buyer. We have a Cyprus corporation that's a seller. The Cyprus corporation has a Russian ultimate beneficial owner. There's a British law firm involved, not our host. And the yacht is somewhere in the Mediterranean. The buyer is presented with documents in Greek. All relevant parties assert that they are, in fact, the certificate of good standing, the authorizing resolution, and the power of attorney. Slight problem. No one in the deal reads Greek. That's when they called the lawyers. After local counsel had been engaged and the matter sorted out, there was another slight problem. The British law firm, as they're wont to do, tells the American law firm, send the money not to the account of the corporation, send it to the account of the ultimate beneficial owner. Right, we're going to do that, especially since we've heard that the ultimate beneficial owner acquired the asset in her divorce from a Russian billionaire. Now, do you want to be dealing with those questions yourself, or would you rather have someone take the burden off of you? If you get a lawyer involved, instead of having to figure it all out, or closing your eyes and hoping nothing will go wrong, if something does go wrong, as someone alluded to earlier, you can always blame the lawyer. And why not? Blaming the lawyer is a long-standing tradition that has stood the test of time. And if you do that, you'll line yourself up with your customer, and that's where you want to be. You don't want to be the person who has the finger pointed at them. You signed up to sell a boat, but if you try to figure it all out, I guarantee one thing, you will go bonkers. And that's where this slide comes in. My second example relates to a situation that happens in virtually all yacht deals, the conditional acceptance. You can handle them on your own if you'd like to, in which case, let's see if we have the text here. You'll end up with a conditional acceptance that looks kind of like this. This was on a major yacht. You accept the vessel subject to some conditions, returning the 2 leather Barcelona-type chairs that were located, this obviously was not my spelling, in the lower saloon. See pictures attached. The closing date extended, which is quite normal, and subject to confirmation of the inventory. So the broker in this deal thought, this deal is clean as a whistle. Everything is agreed upon. Who needs a lawyer? Let's be serious. But you may see that there is a problem with the way the conditional acceptance is written. This conditional acceptance allowed the seller to walk simply by saying this: you can't have the chairs. These are the chairs. Assuming that the chairs or something else or some art collection or something was important, did you really need that? Or did you need something that talked about the certificates that are needed to operate this vessel in compliance with law? A lawyer would have put together an appropriate conditional acceptance, and the deal would not have been subject to being canceled because of 2 ridiculous chairs. Ultimately, although the broker knows what the client wants, on these matters, the lawyer knows what the client needs. Which leads us to the question of what really is the salesman or the broker's job? Once a contract is signed, the most important job is this: focus on the customer and keep the customer from freaking out. This may be counterintuitive to type A salesmen who want to control everything, but that's a mistake. And the bigger the deal, the bigger the mistake. There's so many moving parts in a transaction that the temptation is always there for the broker to try to handle it. And I've seen this repeatedly. But if the broker makes it his or her job to make sure that the meals, the plate comes out on time for the whole table, cooked to perfection, they're going to get stressed out, the customer's going to get stressed out, and it just won't be a pleasant experience. Which gets us to the question of how to best work with a lawyer. And there is an alternative to trying to deal with all these things yourself, and that is to get a lawyer involved from the very beginning. A yacht lawyer. So that on the day of closing, you can be perhaps on the boat with your customer drinking a margarita, and there's somebody else who's going bonkers. And if you do it the right way, you actually get two lawyers for the price of one. A lawyer who's watching out for your customer, and a lawyer who's making sure that you get paid. Now, reference was made earlier to the complexities that arise when a non-yacht lawyer is in a deal, and those are real. I'll talk about them briefly. But to have a lawyer that you recommend in the picture without a conflict of interest can protect you. Now, if you're unfortunate enough to be working with an unamended MEBA agreement, under which all sales proceeds go to the seller and the seller has to then pay the broker, you really have an interest in having a lawyer that you know watching out for you. We've solved most of that in the IYBA agreement, I think. But the commission is only one of the moving parts. You'd be pretty smart to get a lawyer involved in the selection of the surveyor. And in particular, in reading the survey results, they don't have to get into the details, but they do need to understand it with you so that the conditional acceptance can be properly written. And then there is the issue of dealing with lawyers themselves that tend to be quite pushy. I mean, we have a reputation for being jerks for a reason. And if you're a broker on a deal, do you want to be dealing with that pushy lawyer yourself? Or you want a team of lawyers helping you? This is us taking on one of our colleagues. But it's really not about fighting with the other lawyer most of the time. It's about getting the deal done. And when we work with lawyers on the other side who are not familiar with yachts, many of them we know. We can guide them through the process. And if we work with lawyers on the other side that we do know, we trust and respect each other, and we will facilitate things getting done. I'll give you two examples in closing of deals that would not have happened without a lawyer. There was a contract. The seller had signed all the documents in advance, and the seller was now on safari in Rwanda, or some place similar to that, a place that you do not go, that's not famous for being a safari location unless you're insane. The seller was unreachable, and the buyer's lawyer asked on the day of closing for one more document to be signed by the seller. Without it, the threat was the deal wasn't going to close, and the buyer was going to walk away. The broker called us. We looked at the documents, and we determined that document that was being requested wasn't necessary. We had a relationship with the other lawyer, we talked to the other lawyer, we made our case, and that deal closed. Another case, the boat was offshore of Turkey and international waters. It was ready for closing. The buyer and seller's representatives were on board. All that had to happen was for a protocol of delivery and acceptance to be signed. But the seller said to his representative, "Do not sign it until the funds hit my account." And the buyer said, "Don't send the money until it's signed." So there was a stalemate. The situation was brought to our attention and we analyzed it. We found out that the seller's captain was going with a yacht to become the buyer's captain. And the seller's captain was the seller's representative. Understanding that there's no law that governs what a protocol of delivery and acceptance looks like, and understanding that the captain and the buyer's representative both had mobile phones, we requested that the captain send a text to the buyer's representative saying that the yacht was ready for delivery. And we requested that the buyer's representative simply respond, "We accept delivery." This was done, the wire was sent, the deal closed on a 50-meter yacht. That broker was the biggest deal they'd ever done, is grateful to this day. So despite your preconceptions, which are often well-founded about lawyers, given the amount of money involved, I hope I've explained why it's better for your client to have an experienced yacht lawyer, and it's better for you. You'll have someone looking out for the customer, you'll have someone looking out for you, and you'll be working as a team. And if you don't have a yacht lawyer involved, I guarantee something. Especially if it's not a lawyer and your client has a lawyer, you'll be wasting a lot of money and time on legal fees that don't really matter, on issues that don't matter, or that are irrelevant, because the balance of rights between the parties has already been negotiated into the principal agreements in the industry. They've been essentially, the rights and responsibilities have essentially been distributed fairly when you're dealing with an amended MEBA agreement, which is the standard, and when you're dealing with an IYBA agreement. If they do that, they run a serious risk of losing the deal, of blowing up the deal, beyond all the wasted legal fees. And of course, if you have a lawyer involved, looking out for the customer, looking out for you, and something goes wrong, there's always someone to blame. Thank you.